Good evening, everybody. Gives me great pleasure to have Sachin here today. So Sachin has done his BCom, LLB and LLM. He also has a diploma in international law from the London School of Economics. He is currently a partner at Negandhi Shah and Himayutullah, which is one of the leading law firms in India associated with a vast range of commercial transactions involving corporate and civil law issues. Wills. It's a wonderful thing to do because you never know what's going to happen. You're going to be dead when someone is going to check whether your will is good or not. So I think it's important for everybody to listen to how all the complexities of a will. While it sounds very simple, and it also is pretty complex if you don't get it right. You can take the attitude, it doesn't matter, I'm not going to be there in any case when people are going to fight over my will. Or you can say, let me be, as one of his slides will show you, let me do this one selfless act of deciding what to do with my assets when I'm still alive. So with these few words, I'm going to leave it to Sachin.
Good evening once again. And thank you, Sucheta, for having me make this presentation. The first one I'm making to a crowd. As CEO ITCL, we used to do presentation one-to-one, and usually it was a closed room. The first time I'm seeing such a big crowd, and first time I'm realizing that wills is such a big issue for people, because I never thought, honestly, that wills were something that people took so seriously, and people were keen to know so much about wills. A little bit, if I could know what kind of a mix of people I have in the crowd, so at least I'll be better able to organize my presentation. So is it just for a brief testing snapshot? Okay, so wills, nominations and other issues. Let's say when we discuss wills, what does it really mean? Is it really a wish to leave things to your family and to your surviving heirs, or is it a succession planning? So wills, if somebody is to say that, I mean, what do you talk about a will? It's the simplest document to make, because as I take you through the presentation, it doesn't require any special skills. It doesn't require any special paper registration. It's optional. It doesn't require any format. In some cases, even it can be an oral will. Most cases, it is governed by, the laws that govern these kind of wills is so vast that it's really difficult to say how to make a will. But yes, it's an important document, because that's your last testament, and that's what you want to leave a legacy to your survivors and your people who your loved ones after you go. So whether a will is a succession document or whether it is a testament, it's a big debate. Everybody needs a will. There are various ways of planning succession. I'll take you through that. But let me take you quickly through the presentation first. Will as an estate planning tool. Okay, you have wills. You can gift your property before you die. You can put it into a trust. You can nominate people to your bank accounts, as some statutes have now provided for a nomination in Housing Societies Act, in Banking Regulations Act, in Insurances, in the Companies Act. You can have a power of attorney to administer your will, but it's got no meaning, because once you die, the power of attorney has no meaning. Insurance is a succession tool, because after you die, it goes to your survivors. And there is a Hindu undivided family, which is a tax planning structure. So what is a will? It's in law, it's a legally binding document. It is not governed by any statute as such, but there is no format prescribed for it. I won't read what is there, because that's for anyone to read. I mean, anybody can make a will if he's of a sound mind and a major. You can only give away what you have earned. It can't be inherited property. It can only be what you have earned, because heritage, whatever has come from succession, has to go by the succession law to your heirs. Laws that govern succession: we have the Hindu Succession Act, you have the Indian Succession Act. The Hindu Succession Act applies to Hindus, Buddhists, Jains, and Sikhs, and all the tribes that fall under the statute of the Act. There is the Hindu Succession Act has been derived from the various Hindu laws that govern Hindu society and therefore applies to these 4 sects. You have the Indian Succession Act, which applies to Christians, and you may choose to have your will decided by the Indian Succession Act. The Parsis have, of course, got their own law for succession, and so do the Muslims, which is governed by their personal law. The 2 classes of wills which is important to be known at this stage is, one is something that is made by the army officers on the battlefield, which can be an oral will, and which is called a privileged will because they have no means to write the will. And you have the unprivileged will, which is a written will, which every one of us would be making. What are the terms, or what are the terms that we associate with the will? The testator is the person who makes the will. The legislator is the person who derives from the will. The codicil is something which modifies the will from time to time. The executor is the person who you would nominate to execute a will. The administrator is the person appointed by a court to administer the will. And a guardian, testament guardian, as guardian you would appoint under the will if you have a special care situation for either a wife or a dependent or a minor child. Different types of wills. Conditional or contingent will is something which will come into effect on a contingent event happening. A joint will is when 2 people sign it together for different requirements. A mutual will is when 2 testators confer a reciprocal benefit, that is between husband and wife, on each other. Okay, we'll discuss this as we go along. I think why does one make a will? Most important question. It's, as I said, it's your money. You have earned it all your life, and you want to distribute it, and that's why you make a will. It's you decide how you want to distribute your will, how you want to distribute your property. Various questions arise on this, as why a will, and why can't a family decide to have a partition? Well, that's one way of doing it. But a will is it's so personal that nobody needs to know what the contents of it are. I mean, you can disclose the content, but it's something that you leave behind for posterity to decide how your wealth is to be distributed. You can repeatedly revise your will. You can distribute the money the way you want. You need to appoint an executor to the will, which is the most stable thing to do because the executor would be the one enforcing your will. Or you can appoint guardians under the will. The basic requirements of a will. It can be on a plain piece of paper. It needs 2 witnesses. Most important that the 2 witnesses. The witnesses are not required to know what is part of your will, but yeah, it needs 2 witnesses who are of sound mind, who know you. Ideally, it should be your doctor who can certify that you're making a will and you're of sound mind, and it can be anybody else, either a lawyer or a close friend who would survive you. Ideally, it should be somebody younger than you, because they would be the ones who would be testifying that the will was made by you. Every page of the will must be signed as in any other legal document. There is no prescribed format for a will. It can be on piece of paper. No stamp duty is payable on it. You may decide to register the will. There's a debate on whether registered will is much more important or much more powerful or much more stable than unregistered will. But then you can't change it. Once you register the will, if you're sure you don't want to change the will, then of course you go ahead and register it. It can be revoked, it can be updated, it can be modified. You can sign a codicil to include properties which are acquired subsequent to the will being made and how that should be dealt with. Appointment of an executor. This is a very important issue of a will, because the executor would be the one who will be enforcing your will, whether it requires a probate, whether it requires an administration, whether it requires enforcement. The executor is the most important person that needs to be appointed to the will, and it must be somebody you really trust, who is ideally young, who is ideally aware of the affairs of your family, who everybody in your family knows and they can look to for this thing. What is the probate? The probate is a certificate issued by the courts to justify or to say, yes, this is the legally valid will. If there is a dispute among parties, then the probate would be the answer to that dispute. For probate, in presidency towns of Bombay, Calcutta and Chennai, it is a must for all immovable properties. In all other cities, it is, if the will is disputed, you need to approach the district court for getting a probate. Stamp duty varies on it, but the maximum slab is 75,000 rupees. The tools that deal with succession. Gift is something you can do during your lifetime, but you have to determine how the tax liability is and what kind of gift you want to give. Insurance is obviously a question of choice, and I mean you pay your premiums, but your family gets the benefit of it. In a single bread earning family, insurance is a very important instrument to hold. This is the new amendment in the law, which says that the policy can't be attached in the event of liquidation. Now coming to trusts. Now what is a trust? Trust is something that you can set up for succession during your lifetime. You can appoint trustees to manage the affairs of your succession, and you can do your distribution of property in your lifetime itself. So a trust is registered in the Trust Act. You can appoint trustees. There are various trustees available now who do this on a professional basis, who are governed by SEBI regulations. And what needs to be looked at in the trust is the cost efficiency of it. How much is it going to cost to set up a trust? When you transfer immovable property into the trust, it's going to be attracting stamp duty. So those costs are something you need to consider. But a trust can also be set up under will. What you may decide to write a will saying that after this property should go into trust. Trusts are of various functions. You can do charitable trust, you can do private trust, you can do joint trust where something is public, something is private, and decide to distribute your wealth. Costs of a trust is something which one needs to always consider, and also you need to consider the efficiency and the genuineness of trustees who are going to manage your wealth. There have been instances like the famous Birla case where the trustee used to put all the wealth, which is still being argued in the court. So trustees are something which one needs to be very careful of who you appoint as a trustee. The statement says it all. And I presume that with the crowd that we have today, we all have sufficient means for the reason we are looking at why we need to make a will. That's a very short presentation.